3 members to form a quorum. My thanks to Mr. Tommy Chung.
All
right, members from the Democratic Party and Liberal Party are here, and we have a quorum. I invite the government officials to come in. Please invite them in. The administration has made responses to issues raised on the 7th of June. Members, please refer to CB bracket 2 1375/121301. And the Assistant Legal Advisor has written to the administration concerning the title of Section 15A, that is routine inspection. Members, please refer to CB bracket 2 1375/121302 and 03. Might invite the official to take us through paper 1375/121301. Is the supplementary information requested by members? Chairman, I defer to Ms. Lam to take members through the paper. All right. Members, please refer to 1375/121301. Supplementary information supplied by the administration. Ms. Lam, over to you, please. Thank you, Chairman. At the previous meeting, members raised questions, and we supplied supplementary information on questions raised. Firstly, at the previous meeting, a member asked that the appellant can make complaint or appeal to the Administrative Appeals Board, whereas at present the appellant is supposed to make appeal to the CE. Under Cap 442, Section 18 of AAOB, it states that the appellant can be represented by a barrister or a solicitor at the hearing of the appeal. This is to address members' concern as to whether the appellant can be represented at the hearing. Second issue raised was that under the Amendment Bill, Section 15A has a title of routine inspection. The contents of Section 15A was agreed by members. It's just that members had queried whether the title reflected details, the contents of the section. We read it after the meeting, and we propose to change the title of Section 15A. The title reads as power to enter domestic premises without a warrant. And with this amendment, the title will reflect the contents of Section 15A. At the previous meeting, the legal advisor mentioned that CSA is actually an acronym. We explained previously that CAS is a term that is very familiar with those in the trade. We also appreciate that general public may not fully understand the meaning of CAS. So we propose to amend Section 19A(1)(a). That when CAS appears for the first time, the long term will also appear so that the general public will know what CAS, this acronym, means. A member also asked about two schedules. That is, he asked about the Chinese names of the pesticides in the schedules, whether the Chinese names are used in other Chinese-speaking places outside Hong Kong. We explained that the Chinese chemical names as set out in the schedules are official names adopted in the Chinese legal text of Stockholm Convention and Rotterdam Convention. We appreciate that the same pesticide may have alternative names in English and other languages. To facilitate reference by users and members of the public, the AFCD would draw their attention to the alternative chemical or common names which might be used for a given pesticide. So they will take care of the alternative names in English and other languages as well as in Chinese language. This is to better facilitate members of the public and users to understand what chemical, what pesticide we're talking about. The administration also undertook at the previous meeting that there will be follow-up actions. In appendix, there is the list of follow-up actions to be taken up by the administration to further promote the safe and proper use of pesticides. When second reading is resumed, the actions undertaken by the administration will be announced again. That's all I have to say. Thank you. All right. I'll open floor for members. Any questions on 1375, 121301? Members may like to refer to the follow-up actions to be taken by the administration in the appendix. I want to give a fair comment. I think it's fair for them to put it in the list. Any comments from colleagues? If you think the list is not enough, you may like to raise issue of concern. I understand that members are busy, but any comments? Comments from our legal advisor? Any of that? Bracket 02 is the paper written by the legal advisor to the administration. Legal advisor. The paper is about routine inspection. I understand that the administration will remove the word routine via amendment to make the contents and the title in line with each other. We can further look into it later. 1375, 121302. Any questions on that paper? What about the premises? The word premises, have we dealt with that issue? I think you're referring to the change of title. That would be covered by the amendment. Any questions? If not, let's move on to bracket 02. Chairman, I want to go back to 02, bracket 02. Legal advisor, can you confirm that the matter has been dealt with by the administration? Paper 02 is issued to address members' concern about the title routine inspection. In the contents, the element of routine is absent, and the administration now agrees to remove the word routine. So the administration has responded to the letter of the legal advisor and proposes to make amendments. So may I refer members to bracket 04, which is about the amendments.
Yes, would the administration want to bring us through the paper? Yes, Mr. Chan. Yes, thank you, Mr. Chairman. Actually, in the previous meeting, we have already mentioned that there will be this amendments to be moved by the Secretary for Food and Health. And here are the proposed amendments, if we can go through them one by one. First of all, clause 3, bracket 9, in the proposed section 2, bracket 4, in the English text, we would want to delete the purposes of, and that is purely technical in nature. 002, we are referring to section 2, bracket 4. We are deleting the 3 words, the purposes of. That's page 0002. Please look at the marked up copy. Yes, and please refer to the English version. Well, are we referring to the English version? If we are, let's stick to it. Or are we looking at the Chinese version? Well, it seems that, Mr. Chairman, you haven't been here for a long time. You're missing out. All right, well, I get the point. The Chinese version, then. Because the Chinese text sometimes is rather tedious. All right, we're looking at the Chinese text now. Now, but this is a deletion only in English. Exactly, Mr. Chairman, because this is in the English version only, to delete the purposes of, and this is purely of a technical nature. Why do we have to do that, legal advisor? Well, Mr. Chairman, in fact, if I can just supplement, we have talked to the administration, the DOJ, and for the purposes of this ordinance, in fact, is superfluous because there is no real meaning to it. But in the drafting guideline, it says that for any superfluous wording in any ordinance, it is a better practice to actually delete it, and therefore I have questioned this. Well, the administration has come back to say that they can delete the words the purposes of, and the words that follow are the ordinance. But to me, they are one and the same. For this ordinance is really superfluous. It adds no meaning to it. Now, if you just amend the English version without amending the Chinese version, and the Chinese version is very closely harks to the English version, then in fact it adds nil meaning. And if that is the case, it is superfluous and should be deleted. And I have looked at the ordinances of Hong Kong, and there is no such wording for this ordinance. Yes, but the purposes of this ordinance, never. So this is an unprecedented, this kind of wording. Perhaps Ms. Chu, the lawyer, would want to respond to that point. Thank you, legal advisor, for the opinion, the wording, the purposes of this ordinance in Section 2, bracket 4 actually is meaningful because it goes on to talk about the explanations, what kind of pesticides in transshipments, what kind of pesticides are referred to in transshipments. So that is why if we delete the wording, the purposes of, it would be unclear. And therefore, for the purpose of this ordinance or for this ordinance, this kind of wording is actually meaningful. It carries meaning. And our internal guideline does not say that this kind of wording is to be prohibited. It is just that they need not be there if they are not necessary, this kind of wording. But we think that in this scenario, it is necessary. Legal advisor? Well, I've only seen for the wording for the purposes of this ordinance or other ordinance, I've seen those examples. That is to say, the purposes of this ordinance, and then it goes on to list out other ordinances that are relevant. But if we are only talking about one ordinance, which is exactly this ordinance, then this is superfluous to say for the purposes of this ordinance, because of course it is about this ordinance. All right? So now if the government or the administration feels that this is necessary, then I would rather you retain the whole thing for the purposes of this ordinance. Mr. Chairman, legal advisor, in fact, internally, we believe that for the purposes of this ordinance is preferable if the legal advisor agrees. So you're saying that 3 bracket 9, you would want to retract 3 bracket 9 in the paper 1375 12-13 bracket 04. So let's delete that. This is a technical point. 5. We go on to proposed amendment 5. Now, if you remember, in the previous meeting on the 7th of June, we have gone through the detailed background. Mr. Chung, the administration is responding to your point. I know you have other businesses. I apologize, Mr. Chairman. Would you please listen carefully? The administration is responding to your query. Yes. The amended 3A would say this ordinance applies to the government, and despite subsection bracket 1, the government is not liable to be prosecuted for an offense under this ordinance and is not required to pay any prescribed fee. And as mentioned last time, the new 3A, proposed 3A, refers to Cap 618, Section 4, which is the elevator and escalator ordinance. So we have used the same reference to the same ordinance in drafting this 3A section. Any questions, members? This is in response to the discussions in the previous meetings concerning the government's liability to be prosecuted for an offense under this ordinance. I have a drafting issue, 3A bracket 4B, 3A bracket 4B. The English version if the contravention has been terminated, whether it has been terminated to the director's satisfaction. And the Chinese version as follows. If the contravention has been terminated, whether it has been terminated to the director's satisfaction. Well, my question is this word whether. Does it refer to whether the director is satisfied or to whether the contravention has been terminated? Which? Because this section is about the contravention being terminated and whether at the termination the director is satisfied. So in the Chinese version and the English version, it actually means that if the contravention has been terminated, meaning the contravention is already ended. And therefore, the whether in the English version actually refers to the director's satisfaction. So if the contravention has been ceased or terminated, then this clause actually refers to whether the director is satisfied that it has been terminated. Yes, I understand that the English version is the same as the elevator ordinance, but the Chinese drafting seems to be somewhat different. Perhaps Ms. Chu, the lawyer, the administration's lawyer, can answer that question. The English version is perfect, is non-problematic. Well, we thank the legal advisor for the question. During the committee stage in the drafting, we have referred to Section 4, bracket 4b of the elevator ordinance, and in the Chinese version, we have indeed made slight amendments from the said ordinance, so as to make it read smoother, the Chinese version. And in the Chinese version, the whether really refers to the termination. So in interpreting the ordinance and in understanding the intent, the legislative intent, it is correct. There is no misunderstanding of the legislative intent. Well, if you make any changes, of course, it is an improvement. So you think that this is an improvement in the Chinese version, yes? Indeed. Mr. Chairman, perhaps I can make myself clearer. I'm looking at the elevator and escalator ordinance, the text there, and the wording here. It says whether it has been terminated. In the English version, it doesn't say whether it has been terminated full stop, but rather whether it has been terminated to the director's satisfaction. Now, if you look at the Chinese version, it is very clear that the if in the Chinese version or whether in the Chinese version refers to really the director's satisfaction. That is whether the director is satisfied. Whether it has been terminated to the director's satisfaction, you see, rather than whether it has been terminated full stop, or whether it has been terminated as a standalone phrase to be followed by to the director's satisfaction. I think they can go back and think about it. Well, I think they're both problematic. I think if you look at 4A, it says whether the contravention has been terminated. Well, it's either terminated or not terminated. And it goes on. And B, if the contravention has been terminated, whether it has been terminated to the director's satisfaction. But it already says that the contravention has been terminated. So it is the whether does not refer to whether the contravention has been terminated, but rather whether the director is satisfied with the termination. The English seems to be very clear. Terminated to the director's satisfaction is the English text. That is correct, Mr. Chairman. If you say whether the contravention has been terminated in the Chinese version, then 4B really doesn't make sense because the contravention has been terminated. Mr. Chairman, this is wording, but on the other hand, I understand the legal advisor's point, and that is if the contravention has been terminated as contained in the first clause, then it need not go on to say whether it has been terminated to the director's satisfaction. But you see, the point is that the director's satisfaction, no, but rather, what does whether qualify, the word whether? Do you refer to, are you referring to the termination? Well, actually, there are terminations which are not done to the director's satisfaction, you see. That is, the contravention has to be terminated to the director's satisfaction. But that is in degree only. The question is whether the termination has been completed or not completed. It is a either-or situation, not a degree question. All right.
There can be two subsets under the termination. One is that the termination was not to the satisfaction of the director. One is that it was not to the satisfaction of the director. So the first question is whether the contravention has been terminated, and the next question is whether it was to the satisfaction of the director or not. And our case is that the termination should be to the satisfaction of the director. We do not accept any termination that's not to the satisfaction of the director. Sorry, speakers off mic. The director has to be satisfied with the termination. What if the director is not satisfied? Then it should be put down in the report, the director's report. Mr. Chung, the Secretary for Food and Health has to make an inquiry into the case after receiving the director's report. So the secretary has to know whether the director is satisfied with the termination. Otherwise, there will be implication and consequences. The administration can reconsider this, but I think I've made it clear that for 4A, mentions or sets down whether the contravention has been terminated. And 4B should be about whether the termination is to the satisfaction of the director. 4B should focus on whether the director is satisfied with the termination. I think it is. I think I've made it very clear. We should not leave doubts here. The English version is very clear. For 4A, the word whether is used, and for 4B, there are two words that raise question, if and whether. And I think it leaves too much room for possible judicial review. 4A states that the contravention should be terminated, or whether the contravention has been terminated. Now for 4B, there are two limbs. First of all, whether the contravention has been terminated, and second limb, whether it was to the satisfaction of the director. Sorry, Chairman. Maybe in 4B, we should simply put down it was terminated to the satisfaction of the director. Let me read out 4B. If the contravention has been terminated, whether it has been terminated to the director's satisfaction. Legal advisor, perhaps we should let the administration's legal advisor, the government counsel, to consider this point. We leave it at that now. What about Section 7? Any questions? If not, let's move on to Section 7A. Chairman, Section 7A and 8, can we discuss them together? I'm speaking from the perspective of a layman. Members may remember that at present the government is not liable to prosecution under this ordinance, but this is not a protection offered to to public officers. But our colleagues have to enforce the ordinance. For these officers who enforce the pesticide ordinance, he may have to deal with the pesticide concerned. So Section 7 and 8, which are about the license and the permit, they are related to the government and the officers responsible for enforcing the ordinance. At present, the officers are not immune to prosecution. Let's say AFCD officer sees certain pesticides which turn out to be unregistered pesticides. In that case, the officer would be possessing the unregistered pesticides. So in enforcing the law, he is actually breaking the law because he possesses the unregistered pesticides. This is a problem. There's room for discussion. Now, for police officers seizing white powder, heroin, he is technically possessing the drugs. Would he be arrested? But then the officer is responsible for keeping the drugs because he has to keep it as evidence. And for the FEHD officer, when they seize the goods of hawkers, they are in a sense possessing the goods but they are enforcing the law. I'll give you time to speak, Mr. Chung. All right. I want to look at the logic of it. I find your logic really surprising. We have so many law enforcing officers in Hong Kong, and they are responsible for seizing contrabands like drugs, dangerous drugs, guns, weapons. And these people seize and possess these contrabands because they have to take these contrabands to the court as evidence, as exhibits, and they have to give them to labs for test. These officers are not subject to prosecution. Is it a gray area? When police officers possess the dangerous drugs for the sake of keeping them as exhibits, would this officer be prosecuted for possessing dangerous drugs, even though the drugs would be destroyed after the court case? Mr. Albert Chan, the AFCD officers possess the unregistered pesticides. But first of all, they have to seize the pesticides. When they keep the pesticides, is it considered as a kind of possession under the law? Yes. The answer is yes. Let me take Mr. Chang's question. I don't think the scenario mentioned by Mr. Chang will happen. I don't think the officer would be breaching the law because he is in possession of the unregistered pesticides, because he's not liable to legal prosecution. I think it is exactly what 7A1 means. So I don't think Mr. Chang's worry is warranted. My concern is about officers other than AFCD officers. But those retailers who are selling the pesticide, do these shopkeepers know whether the pesticide has been registered or not? They may not know that. They may not know that the pesticide has not been registered before they sell the pesticides. So how are we to address this problem? The paper just supplied to you is not the amendment. Mr. Chen, I think Mr. Chang's question is warranted because I asked exactly the same question when I was dealing with the amendment. There's one important point here. In the amendment bill, it states that the government will not be liable to prosecution, but we do not protect our public officer in this regard. They are liable to prosecution. So it's clear that the public officers are not protected in this sense. However, for other ordinances, such absence of protection is not so explicit. If it's not stated that the ordinance is not applicable to the government, then we have to refer to Chapter 1. For the amendment bill, it states that the ordinance is applicable to the government and the government is not liable to prosecution. But for public officers, they do not have this protection. That's why the officers responsible for enforcing the ordinance and those assisting officers in carrying out the law are included in the amendment bill. And in carrying out this ordinance, these officers, these people, may have to deal with the pesticides concerned. He or she may have to possess the pesticides. Section 7(1) of 133 it says no person shall sell, supply, etc., when they come into contact with the pesticide. I don't think the government should look at these scenarios. That's not the case. We have to buy certain drugs, to see whether some substances are in these drugs. We also seize the drugs or pesticides, and after they have been dealt with, they will go on sale. For example, the drugs or the pesticides are unregistered ones, but we test them and find that they are good pesticides. So after they have been dealt with properly, they will be put on sale. So the government can sell unregistered pesticides. That will be covered by Section 8. For Section 7, it covers the registered pesticides. Even when the pesticides are unregistered, they can be exported. So when people having purchased these pesticides, they want to export, this fine, but they have to get the permit first. Rather, they have to make application first. So the police can possess the drugs. What about police officer wanting to sell the drugs concerned, the drugs they seize? What about C&E officers selling illicit cigarettes they have seized? I think these stories are different from the scenario we have today. Are police exempted from possession of dangerous drugs, whereas the general public can't do that? So police officers are exempted even when they possess dangerous drugs. However, this exemption does not extend to public. Mr. Chung, just now, Mr. Lau from AFCD was talking about samples to be taken for tests and for comparison's sake. So they will be doing the acts in Section 7A. I think the scenario we're talking about is different from your examples. So the government's exemption is extended to cover getting samples for tests. In a sense, I want to narrow the power of the government. I agree that we should allow AFCD to take samples from the market to see whether certain products have been registered or not. I don't have any views providing provision to them to enforce the law in this sense. However, for a police officer seizing drugs, there is no such exemption for this officer. Yet, we are proposing to offer exemption to AFCD.
佢管有幾萬噸冇註冊嘅嘢。
Yes, well, I cannot imagine the officers being prosecuted. I can't imagine that situation, and I can't imagine that the judge would say that the officer is in possession illegally of the substance. Yes, Mr. Chairman, I think Mr. Chung's point is that this is impossible, that this is completely unreasonable, that an officer should run foul of the law because of contact with this kind of substance, or in his carrying out the ordinance, be in possession of the substance. And that is exactly why we have to specify this in the law. A says this subsection does not apply to a person who is engaged in carrying out this ordinance, or B is assisting persons in carrying out this ordinance. I would want to reiterate that in this ordinance we spell this out. We spell it out that the government is not liable, as we have seen earlier, and we also do not want the officers or persons engaged in carrying out this ordinance to run foul of the ordinance. It is exactly because we have spelled it out so clearly about the liability or non-liability of the government that we have to also spell it out for other persons carrying out this ordinance. For ordinances that do not spell out the government's liability, probably they don't have to do so for persons carrying out the ordinance. Well, Mr. Chairman, I do not believe that for other ordinances they need to spell out that persons engaged in carrying out the ordinance will not be liable. I mean, we are talking about small amounts of new products, so samples, or sprays, pesticides in small amounts at the Agriculture and Fisheries Department. Well, for this kind of situation, Mr. Chung likened it to the police department in possession of drugs in carrying out the, or in the execution. Well, in 3A, whom exactly are you referring to? Persons who engage in carrying out this ordinance? Well, we are talking about government officers, for example, Agriculture and Fisheries Department officers seizing unregistered pesticides, and also in Section 18, that there can be confiscation of the unregistered substance or pesticides, and therefore the government can be in possession of the unregistered pesticides. And therefore we have added these two sections, that is 7A and also 8, Section 8, bracket 8. And the reason why we have to spell out this does not apply to a person who is engaged in carrying out this ordinance is to make it clear that such persons will not come under the terms of subsection 1. That is, subsection 1 does not apply to such persons. And for persons who assist persons in carrying out this ordinance refers to perhaps non-government officers. For example, the agricultural fisheries officers may need to engage courier service in delivering the substance to the government lab, and these persons are looked upon as assisting persons in carrying out this ordinance. But in any case, the essence is that these persons will have to be carrying out this ordinance, or helping or assisting persons in carrying out this ordinance. Well, I have to say this is the first time I come across this kind of drafting. The applicability is very wide-ranging because it refers to persons engaged in carrying out this ordinance or persons who assist persons in carrying out this ordinance. Now, if we look at 7A, the applicant for importing the pesticides will have to be licensed. But here, the persons carrying out this ordinance do not have to be licensed, and the persons assisting persons in carrying out this ordinance will not be or need not be licensed as well. And given that analysis, they will not be falling foul of the law, and since they are not falling foul of the law, they do not need to be, we do not have to make any section not applicable to these persons. So you do not have to exempt them from any parts of the law. Otherwise, we are extending the applicability too wide. Now, I would like to ask a question concerning these persons. For example, there are two roles to the Agricultural and Fisheries Department officers. They are the regulator as well as the users. So using the example of the Agricultural Fisheries Department as users in the user role, would this subsection apply if they were the user, the Agricultural and Fisheries Department? Well, I would like to point out that the government or the Agricultural and Fisheries Department would not be supplying illegal substance to, let's say FEHD. Then why do we have to have this point? Well, Mr. Chairman, exactly on the legal advisor's point, because there was this liability to the government, what I'm trying to put in here is an exemption in carrying out this ordinance. In the past, for exemption to the government, basically it just says that there is exemption for government officers. But now we are spelling it out very clearly, and that is such persons are exempt only when carrying out this ordinance. That is, subsection 1 does not apply to persons only when they are engaging in the carrying out of this ordinance. Well, I think our legal advisor, I just have a suspicion. I think, well, the analogy is that you hammer in a nail, and then at the end of the action, you bend the end of the nail. And this is really the analogy here. I don't know whether you get it. In any case, for the Agricultural and Fisheries Department, I mean, it is fine if they have a small sample of certain substance or pesticides and they conduct tests on them. We have no problems with that, and if we exempt those instances of possession. And for persons engaging in carrying out this ordinance, Well, the government officers should be exempted from using or being in possession of the substance. But for any other people, such as myself or Mr. Chan sitting next to me, then we would be liable. But in carrying out this ordinance, the officers should not be liable. And I'm fine with the examples that you have given. Now, if I were to be in possession of these illegal substances, and after that, you are to prosecute me and you confiscate the substance and you sell the substance, I mean, this is all fine. I mean, this should not be liable under this ordinance. I do not see that the government or the department is liable. I mean, even for money used for bribery, if you confiscate the money, I mean, it is good money, it is legal money, and the money can be used. And I mean, I'm just saying that this is completely superfluous, this clause. Now, if you're saying that this allows the officers in getting a small sample of the illegal substance and or unregistered substance and to do testing, then I'm fine with that. But if you're talking about being in possession of the substance and at a later date sell of the substance, then I have a problem with it. I mean, the actions of the Agricultural and Fisheries Department should not be problematic. But what this says here is that where a person in contravention has been seized, and the substance has been seized and the person apprehended, then the department or this subsection does not apply to the officers of the department seizing these substances. Then I find that problematic because it is too wide-ranging and it is the safety net is cast too wide in protecting the government, and I find that problematic. I think when we say carrying out this ordinance, it is very clear we are not opening a loophole at all, because we do mention specific examples as to why this subsection 1 should not be applicable. And Mr. Chung mentioned why he didn't see why possession of confiscated unregistered pesticides should be illegal. Then if you refer to 81E, it is very clearly stated. And as I have mentioned just now, the Officer of Agriculture and Fisheries, because these officers are really in possession of the substances, and therefore we have written it out in no and clear terms. And it was mentioned, Mr. Chairman, just now, whether the officers can therefore provide these unregistered substance to the FEHD or some other departments. Exactly the point here. They cannot, because the person would not be carrying out the ordinance if he does so. Now, we have considered the opinions expressed by the committee, and we are determined in showing that the government does abide by the law, and we have made it clear that the government is not liable. But in carrying out the ordinance, we would want to make sure that the persons who carry out the ordinance or the government officers would not be liable also. I do not see how this is casting the safety net overly wide. We are really just providing for this very special situation. Perhaps the government could go back and think about it, and our legal advisor can also go back and think about it. I mean, if there are substances confiscated, seized, and the public officers are exempted, that is fine. And we can just narrow it down to exactly that. But the drafting here seems very wide-ranging. Why can't we narrow it down? And that is at the point of seizure, what I have seized, or the officers have seized, would be deemed as the officers are in possession of the substance. I think this is too wide-ranging in an exemption. At the point of seizure, the officers actually do not possess the substance. The officer is just carrying out the ordinance. Well, possession does not actually mean ownership. Well, I understand, but the officer, while seizing the substance, is not in possession of the substance. That's how I understand it. Because this exemption seems too wide-ranging. It runs counter to our original intent.
It gives people the wrong impression. It's like you are opening a loophole which is wider than the existing one. Or rather, we should say the safety net is too wide. What about the provision governing the police officers? Say, for example, in seizing dangerous drugs, the officer is holding the drugs. Does it mean that he is breaching the law? Does it mean the officer in seizing guns, weapons, drugs, he is breaching the law? One can't possess weapons or guns. Let me do some research about the other provisions. I only received the proposed amendments at 6 yesterday. I think it's a technical issue as well as one that involves logic. I don't think the proposed amendment can be accepted as it is. Section 7(1) targets the users of the pesticides for importing, sale, and supplying registered pesticides. One has to get a license under Section 7. So the section regulates the users. Under such a section, can we add something that the section is not applicable to the enforcement officer, that is the people responsible for carrying out the ordinance? I don't think the logic is right here. Section 7 is clearly targeting the users. You are regulating the users, those people trying to get a license for the pesticides. So the section should be applicable to the users only. You should not make the section applicable to the person carrying out the ordinance. I'm thinking about another ordinance. If a person who is not registered, who does not have a license, is in possession of broadcasting equipment, the equipment can be seized. Section 7(1). Save under and in accordance with the license, no person shall import into, etc., etc., sell or offer or expose for sale the pesticide. So this subsection regulates any person. It's not just about regulator or regulatees. In enforcing the law, officers will have to seize the products, the substance, and in doing so, the officers are in possession of the substance. If we want to know whether a pesticide, a drug, is effective, we have to first import it for testing. And this person, in doing so, may export the drugs, may put it for sale. At present, the ordinance is not applicable to the government, but after the amendment, the ordinance will be applicable to the government. At present, in enforcing the law, the government is actually doing all these acts stated in the subsection. If we are not protected, I don't know how we can enforce the ordinance. Can you put down no person shall except for the government? Can we put it down? You're right, Mr. Chen. This is exactly what we propose in the amendment. Not all the government officers are exempted, just officers in AFCD. I have to supplement here. Two other departments, apart from AFCD, may be regulated by the ordinance. We just discovered that. So we have to understand from members whether exemption should be provided to these officers. Even if we get the support of members, we have to look at other provisions, other ordinances. As far as we understand, there is similar situation concerning two other ordinances. We have to look at the other ordinances first before we can go ahead with the amendment. I want to know the provisions governing police officers. I understand that in enforcing the law, AFCD has to import the pesticides. And when enforcing the law, the pesticides will be in possession of the officers. I think these are two different scenarios. And you regard the acts as possessing, right? Section 8. Makes it clear that the subsections do not apply to a person who is engaged in carrying out this ordinance or assisting persons in carrying out this ordinance. So exemption is provided to people enforcing the law. But for other ordinances, maybe they is not so clearly spelled out. Section 7(2). Does not apply to person engaged in trade businesses, whether for wholesale, retail, or otherwise, of selling, offering, exposing, for sale, supplying, or offering to supply pesticides, and B, sells, offers, exposes, or for sale, supplies, for or offers to supply any pesticide which he acquired for his own use. This is subsection 2 for the proposed addition. That is subsection 3. It regulates public officers. So are we talking about these officers in the capacity of an individual or in the capacity of a public officer? Because in playing different roles in different capacity, he or she may need to get a license. Legal advisor and government counsel can supplement here. In wearing two hats, the officer may be wearing two hats, but if he's not enforcing the law, the subsection is not applicable to him. So the basis is that he should be carrying out the ordinance at the time concerned. I don't have any supplement at present. I, however, want to point out for the addition of 7.3 and Section 8, the DOJ civil and criminal prosecution units, after reading the draft, are of the view that the two proposed sections should be added. So it's not something that's from come out from the blue, that's out of the blue. For the addition of sections 7 and 8, they actually remove our previous consensus. In carrying out this ordinance, the Section 7 and 8 are not applicable to the officer, so he is not required to get a license. That means even without a license, the officer is not breaching the law. We have different committees in the AFCD, some for country parks, some for fishery. Now, we have to take care of the bushes along the road of the countryside. If unregistered pesticide is used in doing so, the officer is not protected by this section. But we do not prosecute this staff clearing the bush. However, we may seize the pesticide concerned. In a sense, we possess the pesticide, but we are not protected by the law. So this section does not protect everyone in the department. We're just protecting those enforcing the ordinance. I'm not against you. I'm just trying to find out the most appropriate way to write the section. Now, for police officer asking for a check of ID card, he's in possession of my ID card. Is he breaching the law? Mr. Chen, can you make reference with other provisions? C&E police, after seizing the drugs, are they possessing the drugs? For broadcaster, they have to get a license. Without a license and possessing broadcasting equipment, then the government will seize the equipment. In doing so, are the government officers breaching the law in possessing the equipment? Please make reference to these examples we've just given. I don't think they should add Section 7. They should reconsider it. We don't have very strong views. We're just concerned how you can protect officers who possess the contrabands in enforcing the laws. Protect them from being prosecuted in enforcing the law. I don't oppose that. I understand they have to test the pesticides before the pesticide is registered. You may want to use the pesticide to test it in your country parks. We don't have strong views on that. I'm fine with giving exemption to AFCD staff. I'm just concerned about how the section is written here. I don't want to see an exemption that is too wide, too broad. I'm concerned about that. We understand your intent. You understand our intent. Just give it some time to consider it. Mr. Chen, please reconsider it. Colleagues and legal advisor have made their points clear. Mr. Lau and I made explanation, and I'm sure members understand there is a need to have the section. We're not challenging you on that point. So, Chairman, you would like us to narrow down the exemption to assure members. We'll liaise with the assistant legal advisor for further discussion to see how we can draft it in a way that gives more assurances to members. I'm sure members understand we need such a section. We appreciate that AFCD staff have to enforce the law, have to conduct their duties, as mentioned by Mr. Lau. We're fine with that. For the exemption, the way it's written here causes concern, so please reconsider it. The C&E department may also have to come into contact with the pesticides, so we may have to consider the role of C&E, and the Fire Services Department may also come into contact with pesticides, as some of the pesticides are dangerous goods. Legal advisor. Thank you, Chairman. At the previous meeting, we had a consensus on the policy. And at present, the government is proposing to provide exemption to officers. For the sake of keeping record of this Bills Committee, shall we put down the basis for this subsection, for this section, so that we can see whether the intent and the contents are in conflict?
It seems that what we're trying to say here is different from time to time, or the point you're trying to make is different from time to time. So it's very difficult for me to comment on the drafting. Well, for the record, and we will also spell it out in the paper, for 7.3 and 8.8, these two sections, for persons engaged in carrying out this ordinance or assisting persons in carrying out this ordinance, we would want them to be exempted from subsection bracket 1. And also in clause 8, subsections bracket 1 and 2. That's the intent. But in terms of drafting, we can go back and find better wording so as to alleviate any worries you may harbor. Yes, I would like to go back to 7. The original 7 bracket 2. spells out 1, B, and C not being applicable. In the B there, are you saying that for those people who are acquiring the substance for his own use will not come under subsection 1B and C? Is that right? Yes, we are in agreement with that then. But for B, it says sells, offers, or exposes for sale, supplies, or offers to supply any pesticide which he acquired for his own use. Why would a person who acquired the substance for his own use be selling or offering or exposing for sale? Is the drafting problematic here? Because if it is acquired for his own use, why would he be selling? Do you understand my point here? You know, why are we not amending this as well? This is dated 1990, and it doesn't seem logical to me. Can somebody explain, please? Well, this is rarely seen, I have to say. I gathered from seniors in the department and pointing out that some farmers who introduce pesticides to other farmers or neighbors, and even though the pesticides were acquired for his own use, he may sell or offer for sale to his neighboring farmers. Well, in that case, well, these are registered substances. All Section 7 are registered substances. Well, in that case, he is not acquiring for his own use, not strictly for his own use. Let's say you have bought 2 bottles and of pesticides to kill ants, for instance, and if you pass it on 1 bottle to your neighbor, then we can exempt that. So you're talking about small amounts? Yes, we go on. 7 and 8. Shall we continue with the Chinese version? Yes, we go on to section clause 12. In the previous meeting, members had no problems with it, but for the title, because the legal advisor did say that this may be misleading, therefore, in the proposed section 15A, in the heading, we delete for routine inspection and substitute without warrant. And we go on. In the Chinese text, for section 15A 3C, we add the word cup after the semicolon. The English version remains unchanged. For clause 14, again, the 2 amendments to clause 14 are technical in nature. Right. Delete section 5 bracket 3 and substitute section 5(3)(b). Well, clause 18, we were exactly referring to this, the acronym of CAS, as Ms. Lam had pointed out at the beginning of the meeting. We propose in section 19A(1)(a) in the English text to delete CAS, the acronym, and substitute it by Chemical Abstracts Service bracket CAS. This is just for clarification. Clause 20, Mr. Chairman, in the proposed Schedule 2, Part 1, we add asynphos methyl. And in the September Congress in the Rotterdam Convention, the resolution had been passed concerning this substance, and all signatory countries, including Hong Kong, will have to abide by it. Now, because the Rotterdam Convention is already applicable in Hong Kong SAR, so Schedule 2 in Part 1 will also be applicable starting August. And therefore, this substance will be included into Schedule 2 of Part 1 of the ordinance. And when the ordinance is passed, within 6 months of the Gazette date, it will be commenced. And if the second reading is to be commenced again, then we are talking about January 2014 as the earliest date of commencement. And by then, the Rotterdam Convention agreement would have come into force. So we are in time. 25(2). Yes, we have discussed this before, and the legal advisor had raised this point, and that is, in the proposed item 8, delete paragraph A and substitute the wording A for any purposes not specified in item 7, or. And for pesticides and registered pesticides in the schedule, we have basically just specified that these are for purposes not specified in item 7. That's the import of the amendment. For any purposes not specified in item 7. And we have deleted the word other. Legal advisor, I have a suggestion for the administration. I think you will still have to refer to 8 before you can refer to 7 and find out the two usages, and then go back to 8 to find out other usages. Now, if we delete 8 altogether, because the first 3 sentences of 7 and 8 are the same for issue of a permit under the first 3 sentences of items 7 and 8 are the same. And then it goes on to A for 7. And that was 7A. And if I put 8AB up to 7, because import and possess are $700 and the other are $1,280. And the advantage of this is to consolidate the 2 items into one, and that is, where as long as it's not 7A, B scenarios, it attracts 1,280. Yes, if we look at the schedule, it goes on from 1 to 14. And the drafting was that for each of the items, there was only 1 fee mentioned. And for the legal advisor's suggestion, 7 would be segregated into A and B, 700 for A and B, 1280. And this would be different in terms of drafting style. And I'm not in support of that. And the reason why I suggest that is because for 8B, it is actually not very clear. Because it's 8B, if you will just read 8B, it says and there, and actually refers to item 7. But the purpose is not contained in item 7. Now, if you look at item 7, the intention, the fee is $700, and that is really applies to pesticides which are imported but not repackaged and are simply included in transshipments. So this is a situation of cost recuperation for us. For purely transshipments without repackaging. For this kind of scenario, the Agricultural and Fisheries Department actually has less work involved, and therefore the fee is $750. As for other situations, other activities relating to these unregistered pesticides, we will have to look at the import, look at other situations, and therefore more work will have to be carried out, and therefore 1,280 will apply. There is, of course, a possibility that we spell it all out, but we have rather gone for the option of saying either 7 or other situations other than 7. Now, for traders which basically do not repackage the pesticides but export or transship the pesticides, and there are other situations where the trader or the person actually imports and then uses the substance himself or sells in Hong Kong. Well, in all those scenarios, there's only one license that is necessary, and that is a $1,280 fee, rather than to have two situations where the $700 would apply and therefore a total of $1,980 would be collected. Now, if it is only the simpler scenario, $700, transshipment without repackaging. But if it is anything other than that, that is other than item 7, or any usage other than item 7, then there is one fee payable, and that is $1,280 for the license. So this is really to facilitate the industry. So that is the intention, to distinguish between 8A and 8B. Thank you. Any supplement, legal advisor? None. If the government can go back and think about it. This is really technical, purely technical. Let's carry on. Clause 25(4). In the proposed item 14, delete paragraph A and substitute it by A for any purposes not specified in item 13. So this is the same as 8A, except that this is really the fee for extension of the license. Clause 26. In the proposed two technical amendments. Proposed item 73, in paragraph A, delete section 5.3, substitute section 5.3b. No problems? I know the legal advisor has two other points to raise. Concerning chemical toxins, and there are documents being distributed so that we know the points that the legal advisor wants to raise. In my first letter to the administration, I have mentioned that there are two offences in the ordinance, which is not here in this particular ordinance. That is in the ordinance concerning hazardous chemicals control ordinance. And that is providing inaccurate information or misleading information or have complete disregard of the facts and provide false information, then the person is liable. And under Section 41, the employee having engaged in certain conduct or not engaged in certain conduct, the employee's engagement will be deemed as engagement by the employer. As you know, very often when we want to prosecute the employer, it may be problematic because the employer may not be on site. So the employer will have to use his best endeavor to prevent that kind of action from being taken. So this is to help with the execution of the ordinance. Yes, indeed, these points were raised in the letter, and we thank the legal advisor for taking up these points to facilitate the execution of the ordinance. But if we look at the start date of the ordinance starting from 1997, the ordinance had been effective, and the Agricultural and Fisheries Department had never had any problems in carrying out the ordinance, and therefore we feel that we do not have to add these clauses into the ordinance because we only amend it on needs basis. Now, I would like to know whether you will be prosecuting the employer or the employee in this kind of situation. Well, the license are issued. The license is issued to the company, I should say, the licensee, that is. Any prison terms? For the licensee, the prosecution is against the licensee. Is it the company? Well, the company is represented by the board of directors.
Let's say there are 2 or 10 board of directors. All the directors will be prosecuted. And the presidents. Most of the cases we had are quite minor. For first offense, usually that is dealt with by way of fine. So all along is the employer who's been prosecuted. What about the use of false instrument for filling in false or inaccurate information? What will happen? We vet all documents submitted, and if we spot any problems, we would ask the party about any queries. It's only after we're satisfied with everything that the license will be granted. For the use of false instrument, there are other provisions available in Hong Kong to bring the culprit to justice. And in our enforcement actions, we haven't come across any cases involving use of false instruments, so we do not think it's necessary to make available such provision in the ordinance here. Any views from colleagues? If not, let's look at the items, the outstanding items. Section 3A, Section 7 and 8. They are the controversial matters here. How long does the administration need to look at everything again? Just now, you said there are 2 other departments you have to consider. We need some time, Chairman. And we have to consider the time for resumption of second reading. We hope we can make it within this legislative session. I understand we have to submit the report to House Committee by 5th of July, and we have to complete our task before the 28th of this month. Is that right? Clerk, please. The administration has to submit responses to us before we can decide whether we need more meetings. So by the end of next week, we have to clear everything. So please submit information to us by next Tuesday latest, and then we can have a meeting on Friday next, so we can meet the July 5th deadline. In any event, we should have a meeting at the end of next week. I agree. If we find that the outstanding matters can be dealt with in a simple manner, then we can have a 5-minute meeting only. Chairman, sorry, I will be on leave next Thursday and Friday. Can we bring the meeting forward, say next Wednesday? We have council meeting next Wednesday. And we need 3 members to form a quorum. PWSC, ESC, and some other meetings are scheduled next Wednesday. So I wish you luck. What about Tuesday? If it's Monday, then 4:30. Can't make it on Monday. We have 7 members, and except Ms. Wong, the other members are fine with next Monday. So 4:30 next Monday. Let's put it down. If you want to make any changes, please liaise with the clerk. I won't be in Hong Kong starting from the 26th, so it's best that we clear everything by 24th. But I'm not optimistic, because it seems to me they are proposing a wider and broader exemption. We may need some pesticide here. I hope the next meeting will be our final meeting, our last meeting. So next Monday, 4:30. I'm not optimistic, however.